California Civil Procedure Handbook rules, selected statutes and cases, and comparative analysis, 2007 to 2008. Chapter 4, the proper court. Subpart A, subject matter jurisdiction. Part 1, California trial court unification. Prior to 1998, California's trial courts consisted of superior and municipal courts, each with its own jurisdiction and number of judges fixed by the legislature. In June of 1998, California voters approved Proposition 220 and thereby amended the California Constitution to permit superior and municipal courts within the county to consolidate their operations if approved by a majority of the superior court judges and a majority of the municipal court judges within that county. Citing California Constitution Article 1, Section 5E of 1998, in counties that vote for unification, there will be only a superior court. The judgeships in each municipal court in that county are abolished, and previously selected municipal court judges will become judges of the superior court in that county. By March 2001, all 58 counties in California have voted to unify their municipal and superior courts into a single superior court. Subsequently, in November of 2002, the California voters approved Proposition 48 and again amended the California Constitution, this time to eliminate references to the constitutional authority to vest judicial power in the municipal courts, which repeals California Constitution Article 6, Section 5, 6, 8, 16, and 23 are cited here. As a result of these constitutional amendments, the Superior Court now has jurisdiction in all matters that were previously under the jurisdiction of either the Superior Court or municipal courts. Even after unification, however, the jurisdictional differences between the Superior Courts and the former municipal courts remain relevant for purposes of certain trial court procedures, such as the size of the jury, and for purposes of the proper court for appellate review. The courts of appeal have appellate jurisdiction as to the type of cases that were within the original jurisdiction of the superior courts on June 30, 1995, and in other cases are prescribed by statute. As to all other cases referred to in the legislation implementing Prop 220 as limited civil cases, the appellate division of the Superior Court has appellate jurisdiction. And we keep citing California Constitution Article 3, Section 11 here, and then the CCP Section 77 to 86, Section 904.2. Under the current statutory scheme, the definition of limited civil cases corresponds to the type of cases that could only be heard in municipal court. Prior to unification, for example, generally civil cases in which the amount in controversy is $25,000 or less. CCP Section 86, the legislature has authority to change appellate jurisdiction of the courts of appeal, and therefore necessarily of the appellate division of the Superior Court by changing the jurisdictional amount in controversy. That same Section 11 of the Constitution, California Constitution, Article 66. Okay, so now we're at Subpart 2, which is titled Limited and Unlimited Civil Actions. Limited civil case. Generally speaking, a limited civil case is an action in which the amount in controversy does not exceed $25,000. This again is a 2007 and 8 edition, which is quite some time ago. I think it might have raised. This is cited in CCP Section 85A and 86A, which designates various specific actions as limited civil cases. An unlimited civil case is an action which seeks more than $25,000 according to CCP 88, or one designated as an unlimited civil case by statute regardless of the amount in controversy. See Family Code Section 200, 4900 through 4976, and 8500 to 9206 regarding dissolution of marriage, adoption, and support proceedings. Probate Code Section 2200, 7050, which regards to guardianship, conservatorship, and probate proceedings, and CCP Section 1250.010 regarding eminent domain. Although the procedural laws applicable to civil actions generally also apply to limited civil cases, CCP Section 90, there are some provisions applicable only to limited civil cases. These include limitations on pleadings, CCP 92, simplified discovery, CCP 93 through 96, admissibility of affidavits or declarations in lieu of direct testimony, CCP 98, lowering filing fees, Government Code 7255, and appeal to the Appellate Division of Superior Court instead of the Court of Appeal, CCP 904.2. Reclassification. The clerk makes the initial jurisdictional classification of a civil case based on the plaintiff's justification or classification designation in the caption of the complaint, CCP 422.30b, Rule 2.11110, California Rules of Court. A party or the court on its own motion may move for reclassification of a case that is erroneously classified, CCP Section 403.040, if a party files an amended pleading or a cross complaint that causes the action to exceed the maximum amount in controversy or otherwise fail to satisfy the requirements for an unlimited civil case and pays a reclassification fee, the clerk may change the jurisdictional classification from limited to unlimited, CCP Section 403.020 and 030. See also CCP 403.050 regarding reclassification pursuant to parties' stipulation. Amount in controversy is the next section, followed by judgment below, classification, minimum amount, small claims court will be the last part in the subject matter jurisdiction sections. So as to amount in controversy, the amount in controversy means the amount of the demand or the recovery sought or the value of the property that is in controversy in the action, exclusive attorney's fees, interest, and costs. CCP Section 85A, when a single plaintiff alleges multiple causes of action against a single defendant, the demands of the claims are aggregated in computing the amount of controversy. See Hamill v. Superior Court of 1932. Next mini section, judgment below classification, minimum amount, when a good faith demand in the complaint exceeds the amount necessary for classification as an unlimited civil case, but the subsequent judgment is one that could have been rendered in a limited civil case, the court is not required to reclassify the action as a limited action, but may refuse to award costs to the prevailing plaintiff. CCP 403.040E and Section 1033A, when a plaintiff in a limited civil action recovers an amount within the jurisdictional limit of the small claims court, the court may deny costs to the prevailing plaintiff or may allow them in any amount that's deemed proper. CCP Section 1033B. Last mini section, small claims court. Each superior court must have a small claims division. CCP 116.210. Generally speaking, the small claims court has jurisdiction in actions to recover for recovery of amount money and the amount of the demand does not exceed $5,000. CCP 116.220A, in such actions, CCP 116.220B also authorizes the court to grant equitable relief in the form of rescission, restitution, reformation. Specific performance is the small claims court jurisdiction exclusive or concurrent with superior courts on matters where the demand does not exceed $5,000. See CCP Section 85A, 86A, and the discussion of unlimited civil cases, supra. A plaintiff who files an action in small claims court waives any damages above the jurisdictional limit, CCP Section 116.220D. A plaintiff who litigates in small claims court has no right to appeal the judgment on the plaintiff's claim, CCP 116.710A. However, the defendant with respect to the plaintiff's claim and the plaintiff with respect to the claim of the defendant may appeal the judgment to the superior court. CCP 116.710B. The appeal consists of a trial de novo before a superior court judge, CCP 116.770. And then personal jurisdiction is subpart B, regarding the Part 1, the California long-arm statute, 2, due process, minimum context, general versus specific jurisdiction. There'll be some discussion of that and notes regarding it, and then we'll get to subpart 3, due process, the effects test from Pavlovich versus Superior report. With a dissenting opinion as part of this text. Case notes are fairly short before subpart 4, raising the personal jurisdiction defense. The California Code of Civil Procedure from 2007 is then given. Notes regarding that and form selection agreements is subpart 5. Before we reach venue, subpart C, venue. So we've got quite a bit, 20 pages in subpart B that we'll catch up on another reading.